open that public hearing, and I'm going to ask for Senator Sollman to please come forward. And Senator, it looks like Senator Weber was scheduled, but she's no longer scheduled to testify. So we'll let you open, and then we'll pick up the rest of the testimony.
And she's absolutely in support of this work. So thank you so much. Good afternoon, Chairperson Sansky.
Before we get started, I apologize. No. I jumped the gun and said get started, but
yes.
We have an overview.
Oh, absolutely.
Everyone has it.
We're ready. Chair Przanski, members of the committee, Senate Bill 710 directs the Judicial Department to study options for domestic and sexual violence training programs for judges and to submit a report to the interim committees of the Legislative Assembly related to the judiciary no later than September 15th, 2026. The measure sunsets on January 2nd, 2027.
All right, thank you. Senator.
Thank you so much. Good afternoon, Chair Przanski, Vice Chair Thatcher, and members of the committee. For the record, I'm Janine Sollman. I'm the state senator for Senate District 15, which includes areas of Forest Grove, Cornelius, Hillsborough, and the Rock Creek area of Washington County. I come to you today in support of Senate Bill 710. As a senator and a board member of the Family Justice Center of Washington County, I have heard from numerous advocates and survivors that improvements to the family court system are much needed in order to protect children and survivors of abuse and domestic violence. We must have better training and awareness of for our judges all across Oregon. It can have dire consequences if they do not have this trauma-informed training. As a survivor of domestic violence myself, growing up in a home where violence was traumatic and a constant pattern, I understand this pain and the fear and critical safety for young children specifically. In 2023, I brought forward a bill called Caden's Law, and that sole focus was about keeping children safe from family violence. This was a bill based off a tragic story in Pennsylvania that saw a young child, Caden, murdered by her abusive father during an unsupervised court visit. Despite the court's knowledge of the father's history of violent and threatening behavior, a portion of Caden's Law would have mandated judicial education so that judges would receive initial and ongoing training on domestic violence and child abuse. And this was in order to prevent further tragedies like Caden's from occurring. Chair Przanski understood the need for this awareness and continued conversation and provided us with an informational hearing. And since then, I have been working with advocates and survivors alongside the Family Justice Center of Washington County, Oregon Law Center, and the Oregon Judicial Department on a concept focused on the judicial training piece. The language for the judicial training is forthcoming. The advocates can speak further to the details, but I just really wanted to be sure and give a special thank you to the advocates that are here to speak to you today. Because reopening trauma is not easy for anyone. And in our search for positive change, we ask them to come back again and again and again to share their stories. Judicial training is the important first step in addressing the trauma and safety for DV and sexual assault survivors. We have much work to do, and I look forward to working on these issues in the future. Thank you so much.
All right, thank you. Any questions for the senator? Thank you. We're going to go ahead and pull up our first panel. Looks like I'm going to go with the Oregon Department of Justice. Looks like we have Matthew Shirtcliffe, Rebecca Guptel, and Aaron Knott. Okay, I said that wrong. Judicial. You know, it's just old times. I got to break these ways.
Chair Przanski, members of the committee, I find myself thinking of myself as the Department of Justice from time to time. For the record, my name is Aaron Knott. I'm the Director of Government Relations and Communications for the Oregon Judicial Department. The O, the J, and the D are all still there. They've just moved a little bit. And we are here in support of Senate Bill 710. We'd like to offer our thanks as well to Senator Sollman and the advocates who will appear after us, as well as the judges that are taking time out of their busy schedules to talk to you today. And we'll make up the bulk of our testimony. Domestic violence and victimization, trauma, I mean, these are dynamics that can impact how somebody shows up in court significantly. It can impact memory, it can impact how they testify, and it can impact what it takes for them to have a good experience in the court. And so we are on board with this project, but when we were approached and asked to look into it, one of the challenges I think we're confronted with is we actually don't have a mechanism for delivering this training now. And that's one of the things that we're working through with these amendments. Training has been a priority at OJD, but the funding has not always been there and the structure has not always been there to provide organized continuing training to judges. We think that this proposal moves that ball downfield and moves it downfield on an incredibly important subject. So we all are still working through the language of the amendments. I've tried to forecast them to the best of my ability on OLIS. But we are mostly just here to talk through those implementation questions. I think the people you really need to hear from are the two judges that have joined us today. We have Judge Shirtcliffe and Judge Guptill in either order. So
All right, thank
just
you.
whoever's ready to go.
I just see no one coming up, so why don't we go ahead and go with?
There's one.
There we go. We have a volunteer. Thank you. If you'd be so kind to give us your name before your testimony. Thank you, Your Honor.
Thank you. Thank you, Chair Brzezinski and Vice Chair Thatcher and the members of the committee. My name is Rebecca Guptill, and I'm the presiding judge of Washington County Circuit Court. I'm here to support SB 710 in concept in my individual capacity and based on my experiences as a judge who has presided over dockets involving family law, criminal law, and other areas involving and impacted by both domestic and sexual violence. I also previously served on the board of the Family Justice Center of Washington County for 5 years. Prior to taking the bench, my practice included family law, criminal defense, and juvenile law. Domestic and sexual violence are all too common, and the trauma and cyclical trauma caused by both can be seen in all types of cases that come before the courts. There's currently no mandated training specific to educating judges on how best to handle these matters. Occasionally, a training may occur on these issues or touch on these issues, but not all judges likely attend for a variety of reasons, often a lack of time. Currently, judges have the same continuing legal education or CLE requirements of all other practicing attorneys. Oftentimes, meeting those requirements requires spending time engaging in CLEs. They're not at all specific to judges and what we do. Often, judges are teaching those CLEs and getting credit as a result of doing so. The CLE requirements do not include a requirement for domestic and sexual violence education, and even if they did, it would be unlikely to provide skill-based education geared toward the needs of judges. It is my opinion that judges would benefit from their own judicial education standards for continuing education rather than the current requirements that do not provide high-value specialized training for judges. The proposed mandatory training regarding domestic and sexual violence should be part of the judicial continuing educational requirement and should include evidence-based and trauma-informed education that provides specialized practical training for judges. Domestic and sexual violence and the trauma it causes impacts every type of case coming before the court. And not all judges have legal backgrounds that have provided experience or education on recognizing or dealing with trauma. I'm lucky to have practiced in legal areas that provided me with exposure to and some education related to domestic and sexual violence. But it was still not specifically toward judicial educational needs. This can become most obvious in the area of family law, where many cases directly involve domestic violence in a home. Currently, 86% of family law cases in Oregon have at least one self-represented party. It is common that a court might have a self-represented litigant who presents differently based on past trauma and the stress of the courtroom experience, particularly if that litigant is sitting in the same courtroom and up against someone who is abusive to them. Recognizing that dynamic and understanding it is crucial to being able to manage the courtroom and proceedings in those situations and to being able to make accurate credibility determinations, ensure that necessary information is obtained through the process, and to provide a more trauma-informed courtroom experience. This really necessitates judicial training that is ongoing and recurring to both teach initial skills and also to help judges refine those skills to ensure they are being applied effectively in the courtroom. This training should be developed to be judge-specific, but also to be in collaboration with community partners and an advisory committee formed by the Chief Justice. Currently, there is a 1-hour session during the new judge training seminar related to domestic and sexual violence, and OJD recently had 2 one-hour sessions on the dynamics of domestic violence at its judicial conference. In addition, the State Family Law Advisory Committee has developed FAPA and ERPO bench books and bench cards for judicial use, but those materials don't necessarily address the courtroom dynamics judges must understand and manage in cases involving domestic and sexual violence. Judges are in need of additional, more specialized, professional training on domestic and sexual violence, and in particular, skill-based and evidence-based training to include training related to understanding trauma responses and also how to manage those dynamics in a courtroom. This level of training will improve the experience of litigants and others who come into our courtrooms, provide better access to justice, improve our ability to make accurate credibility determinations, improve outcomes overall, and quite simply help judges to do our incredibly important job better. Mandated training will help promote accountability to our independently elected judicial officers. This level of training requirement will also need to be adequately funded so that we can truly provide professional and effective training to our judges. Judges need to have practical, ongoing education and training that is geared toward what we do every day and not the current CLE requirements that don't provide training focused on judicial educational needs. I hereby provide my support for SB 710 and its concept of providing mandated specialized education to judges in the important area of domestic and sexual violence. I'm happy to answer any questions. Thank you for your time, Chair Przansky, Vice Chair Thatcher, and members of the committee.
All right, thank you, Judge Goptel. Do you have time to hear Judge Shirtcliffe, and then we could open up for questions for both of you at the same time, or do you need to get back to the bench?
I do have people waiting for me, but they can continue to wait.
Uh-oh. Well, as long as I'm not going to be held in contempt, I will.
Not today.
Okay. So, Judge Shirtcliffe, if you'd be so kind to identify yourself and give us your testimony, please.
Yeah, Matt Shirtcliffe, 2710 Main Street, Baker City, Oregon. Chair Przansky and Vice Chair Thatcher. Again, I'm Matt Shirtcliffe, the presiding judge in Baker County. I was a deputy district attorney for 6 years and elected district attorney in Baker County for 19 years. I spent 25 years as a prosecutor, and I've been on the bench now for 5 years. With that background, I've had a lot of experience with domestic violence. I've prosecuted a lot of cases, worked with the community here in Baker on these issues, spent time obviously dealing with them on the bench. I've dealt with them with the implementation of Senate Bill 48 when we looked at the issues related to domestic violence involving pretrial release. And I, like Judge Guptill, agree this is a huge area and critical area of importance for training for judges. We all come to the bench with different backgrounds, and some backgrounds we're stronger in and others not. I didn't have a lot of civil experience when I hit the bench, but I had a lot of criminal law experience, so I had experience in this area. But Judge Guptill's right. These issues of interpersonal violence, domestic violence, sexual assault, they overlap into other areas of law that we deal with on the bench, and they're pervasive throughout. Domestic relations cases, they come up, and folks that are not represented by attorneys, and there's just a lot of nuances to being able to handle these cases properly. They really are nuanced, and trauma, best practices dealing with trauma, victim dynamics, recantation, confrontation issues, constitutional confrontation issues in the courtroom, hearsay issues as the hearsay laws develop, the evidence code develops around domestic relations, community responses. All of these areas are areas that we need training in. And judges need training in. Many judges don't come to the bench with any of this background, especially the science and the dynamics of domestic violence. So for judges that don't have much experience in this area, it's critical that they get this training. And for judges that do, like myself, we still need upgraded best practice training as time goes by as we're on the bench. I know as a prosecutor for a lot of years, the way I dealt with victims when I first started and the way I dealt with them towards the end of my career were drastically different because of trauma and trauma-related best practices and issues that we learned along the way. There's simply no reason why prosecutors should have that in-depth training and judges not have that knowledge. We're running these cases and we need to have that kind of training as well. In my opinion, the best way to deal with this is kind of what I call kind of like a graduate school or an advanced training course. And we've talked as PJs, presiding judges, a little bit about this just recently. But I think Senate Bill 710, Judge Sollman's bill, kind of pushes this across the finish line in a lot of ways if it can be done right. We come in as judges, we get, as Judge Guptill described, we get CLE trainings like lawyers do, and we go to conferences, and they're good. But the only real sort of intense training we get is at the very beginning. We have a week-long boot camp for just basic beginning judging. My thought would be that over the first 2 or 3 years on the bench, we should be required to receive a week-long advanced training on these issues. Domestic violence, sexual assault, the dynamics, the science of it, so that we have this knowledge, and the judges that don't have the knowledge can gain it, and the judges that do can continue to stay up on best practices, and the judges should be required that have been on the bench for a while to maintain this training every few years. I think this type of training also could be developed for other areas of law as well. It's more intense and deals with sort of smaller groups. I think this needs to be handled underneath the chief. It needs to be implemented by the Chief Justice. And her committees right now allow for and set up for this kind of setting up training, but there will be resources involved with that and setting up this more advanced type of training. Obviously resources for developing this around the state, for funding that type of training, but also, you know, I know when I go to a week-long training, a Plan B judge, a senior judge has to come in. I'm the only judge here, and I need my docket to continue to move. And that's really the way it is all around the state. So there need to be funding, additional resources for judges to be away, especially in that first few years while they're receiving this training. And so that's something that would need to be added and really looked at as well. You know, I just tell you, I obviously handled a lot of domestic violence cases. I'm from a small jurisdiction, but primarily the homicides I dealt with were domestic violence homicides. These are critical cases that have to be handled correctly, and judges need to be running them correctly and overseeing them correctly. And so the only way I see that happening is with consistent statewide training at a more advanced level. And so that's really what I have. I think this overall advanced course type of a structure would be good underneath the chief. I think it would move us to that next level. I think it could be developed into other areas of law where judges come in with a little bit less experience in certain areas, and that's something that could continue to develop. But ultimately, the chief needs to have the flexibility to implement this and the resources to do it. And I think if that happens, I think the bench will be a lot stronger, and there will be a lot more accountability around what we do, especially in those first early years on the bench. And so I look forward to this moving forward, and I hope my input's been helpful. And so I appreciate your time and the ability to give this input. Thank you.
All right, thank you, Judge Shirtcliffe. Let me ask committee members, any questions for the judges?
Maybe for Aaron, but I don't know about judges.
All right.
It's more of a comment.
All right, well, what I want to do is release the judges because I know that they have tight dockets. So, Your Honors, thank you very, very much for taking time out of your day to express and give your testimony today. We really do appreciate you taking that time. So you can feel free to disengage with us and go about whatever else you need to do. And thank you again.
Thank you.
Thank you so much. Have a great day.
Thank you. Senator Thatcher?
Thank you. Since you represent Oregon's Judicial Department now, I just thought I would throw out that I think this is very important training. I think it is needed for the reasons spelled out. One of the other things that I would also like to throw out there is to watch before and maybe train in while talking about domestic violence. Also, how to detect when a parent is using a child as a weapon against the other parent. And because that is also a form of child abuse.
Chair Przanski, Senator Thatcher, thank you for that comment.
Any other comments or questions? Not seeing any. Thank you very much.
Thank you, Chair.
You bet. So I have 3 other individuals. Let's see, make sure. I think, no, 4 more individuals to give testimony. So I'll call up in panels of 2. Let's see, they're all, looks like everyone is in person. So if please, let's see, Rachel Schatz and Lisa Jones.
Good afternoon. Thank you for having us.
You bet. When you're ready, just your name before you give your testimony, please.
Thank you. Chair and members of the committee, my name is Rachel Schutz, and I'm the Executive Director of the Family Justice Center of Washington County. And thank you again for hearing us today. We really appreciate it. I am here in strong support of Senate Bill 710, which is critical for ensuring that our judicial system understands and appropriately responds to cases of domestic and sexual violence. I've spent almost 20 years in social services with children and families and have seen many, many cases of family violence. However, it was not until I began my time at the FJC 4 years ago and was fully immersed in this field that I actually understood the deep and insidious complexities of violence and abuse. That is because it is neither common knowledge nor common training, which makes this bill both unique and necessary. Every day, survivors and their children enter courtrooms across this state, across our county, and also in our center because we host our own court there, seeking safety and justice, yet too often face a judicial system that may not fully understand the complexities of family violence, coercive control, and trauma. This education gap can lead to devastating outcomes, underestimating an abuser's danger, minimizing a survivor's experience, or making custody decisions that put children at risk. As was the case in my career, this is not for lack of caring about these survivors, but for a lack of understanding about what abuse really is and the impact that it has. My time in this field has also taught me that domestic and sexual violence in Oregon is higher than the national average, with a majority of Oregonians experiencing domestic violence, sexual violence, or trauma as children when they're growing up in their homes. That means that education on the impacts of domestic violence, sexual assault, and trauma need to become commonplace because it is unfortunately Oregon's common experience. Senate Bill 710 ensures that every circuit court judge receives trauma-informed, evidence-based education on the dynamics of abuse, risk factors for lethality, and the impact on children, and more. This bill is not just about education, it is about saving lives, as the judge talked about. When our judiciary is better informed, survivors are better protected, and justice is better served. By passing this bill, Oregon has an opportunity to offer what survivors define as true justice: being heard, being understood, and being believed. I urge you to support this bill and ensure that every judge has the knowledge necessary to make informed, life-changing decisions. Thank you.
All right, thank you. Lisa?
Hi, good afternoon, Chair and members of the committee. My name is Lisa Jones, and I am here as a survivor of domestic violence, a mother, and a passionate advocate for change. I serve on the Voices Survivor Committee of the Family Justice Center of Washington County, where I work alongside other survivors to improve support systems and advocate for policies that protect those affected by domestic violence and sexual assault. I'm here today to urge you to pass Senate Bill 710, which will require mandatory domestic violence and sexual assault education for all judges and court staff. My experience in the family court system was not one of protection, but further harm. Instead of being recognized as a survivor, I was treated as a perpetrator, forced to defend myself against assumptions while my abuser remained unaccountable. The biases and lack of trauma and abuse-informed understanding in our court system led to devastating consequences, not just for me, but for my children. When my mother, who was my strongest support and my designated safety service provider, passed away, my children were suddenly taken from me based on uninvestigated assumptions, not facts. They were placed in a system that overlooked the real trauma we had endured. My young son was separated from me for months, and when he returned, he was no longer the joyful child I had once known. He was later diagnosed with complex PTSD, a direct result of the court's decisions. This is why we must support this bill for universal domestic violence and sexual assault education for judges and court staff. Too often, survivors are met with skepticism instead of support. In my experience, without this education, courts rely on outdated myths, personal biases, and incomplete CPS reports, rather than understanding the realities of abuse and trauma. At the core of this issue is a simple truth. We need to believe survivors. When we fail to do so, we allow injustice to continue, re-traumatizing those who have already suffered. Believing survivors means making informed decisions based on facts, not assumptions. It means recognizing that domestic violence does not always look the way we expect, and that the legal system should not punish people for surviving. With the training proposed in this bill, judges and court staff could better recognize the nuances of trauma, the power dynamics in abusive relationships, and the ways the system itself re-traumatizes survivors. They could make informed, just decisions that prioritize safety and healing rather than perpetrating harm. I urge you to support SB 710 to ensure that our courts do not continue to fail survivors like myself and my children. Judges have immense power over our lives. Let's make sure they are trained to use it responsibly. Thank you for your time.
All right, thank you. Thank you for being willing to come give your testimony.
You're welcome.
I made a mistake when I was looking at we only have one other person that was going to be giving testimony, and I think may be part of your group, which is Jen Bartholomew. Why don't you come on up and give your testimony, then we're going to open it up to the panel for questions. And the other witness is on the next bill that we have.
Put my glasses on to read my paper.
And Jen, if you could just move the microphone just in your direction. Thank you.
Like that?
Yeah.
Okay. Thank you for allowing me to speak today. My name is Jen Bartholomew, and I'm a member of the Voices Survivor Advisory Committee with Family Justice Center of Washington County. I am an intelligent, empathetic, and great mom. I am also a survivor of nearly 25 years of psychological, emotional, and financial abuse. I know many other women and some men who have been coercively beaten to the point of paralysis by people claiming that they love them. I was on the verge of suicide and trying to protect my kids from the abuse of their father when I finally found the courage to file for divorce. I felt helpless and scared. Every time I tried to reach out for help, I was told I had no recourse. From the police, DHS, Washington County Circuit and Family Court, Coalition Services, I was never assigned or directed to a single resource. So I counted on the judge in my case. The urgent need for training and understanding of domestic and sexual abuse and violence within our legal system must be acknowledged. It can't be optional for judges to know about or believe in the prevalence of abuse, nor should it be optional to educate purveyors of justice about what justice is for survivors. Abuse is running rampant in our homes, and our judges don't see it. The system must know that these challenges start the moment survivors file and continue well past the date in court. Judges must be trauma-informed and educated on the dynamics that survivors face so they can play the pivotal roles that they're elected to play. Without training, judges go blindly into potentially serious situations, particularly for children who are most vulnerable. Abuse knows no age or gender and extends far beyond physical violence. Coercive control is a significant form of abuse. I was verbally assaulted, threatened, humiliated, blamed, and gaslighted my entire marriage. This was obviously not acknowledged by my ex. Judges need to understand that attorneys often do not care if their client is an abuser. Equally important is the awareness of loopholes that abusers can exploit. Our judges must approach cases with the knowledge that abusers prioritize winning over justice. It's the judge's responsibility to see through that deception and find the truth, especially when the survivor doesn't have an attorney and the abuser does. That alone should speak volumes. That was my case. Judges must be trained to identify flags like this that point to abuse and trauma. My own experience is a testament to this. My abuser spun a web of lies. Despite my many attempts to disclose the truth, it fell on deaf ears because his attorneys worked for him. My voice was not heard, and I wasn't allowed to speak to the judge directly. The adversarial nature of our legal system dismisses real human suffering. Court is a game of money and power where the truth is subjective and survivors are silenced. The system can and does inadvertently protect the abuser. When the signs of trauma and abuse are missed or ignored, judges' rulings can subject victims to further abuse. This happened with my children. Spending time with their father wasn't against the law, so their father won court-ordered time despite my children begging not to be forced there. This gave him a new kind of power, which he called the law, and held over his children and me as a threat regularly. Ongoing training that emphasizes the nuances of domestic abuse can't be optional. These are real lives that are being further destroyed by a system that should be protecting them. I urge you to support initiatives that enhance judges' ability to recognize and respond to domestic and sexual abuse and violence. Training and awareness is essential for creating a judicial environment that validates victims' experiences and restores faith in this system. Please pass Senate Bill 710. It's up to judges to make final rulings that keep people safe, and this training will literally save lives.
Jen, thank you as well. The committee thanks you for coming forward and giving your testimony. Colleagues, any questions for the panel? Again, thank you very, very much for being here today.
Thank you.
Thank you.
That, I will just ask, since we do have a little time, is there anyone else that wanted to register to give testimony on 710, Senate Bill 710? Not seeing anybody coming forward, not seeing anything on video. We'll go ahead and close the